Thank you, Mr. Chairman. My discussion this morning, I would like to focus on some of the smaller local groups that are claiming tax-exempt status. And these are groups that are unapologetically politically involved. I mean, in fact, they were formed around that idea. What would a small group in a suburban town that might have 60 to 80 members, what is the most likely organizational tool that they would file in order to be tax exempt?
Are these organizations coming in as 501c3s, or would they be coming in as 501c4s?
Well, I think that's my question. What would be the most efficient, as far as compliance goes?
So if they're really doing politics, Congressman, they really can't be a charitable organization under the Internal Revenue Code.
So would they be a tax-exempt organization?
So they could be one of a couple of things. They are permitted to have some politics in their business if they're a 501c3 social welfare organization, although they need to primarily be engaged in other than politics. They can do some work if they're a labor union, or if they qualify that way, or as a trade association. Those are also able to do some politics. But if all they're going to be doing is politics, then they probably should be a political organization that we would describe under Section 527, a PAC.
And so if they don't file for the 527 PAC designation, many of these groups are now contacting our offices. I can speak for myself. I've been contacted by several of the groups in my district, and they feel like they are being harassed. I don't have any evidence that that's the case, but they feel like they've been harassed and feel like that the IRS is threatening them with some kind of action or audit. What kind of a letter or action is taking place at this time that you're aware of?
So if we're talking about social welfare organizations, C4s, 501c4s, then we did receive quite a few. We received an uptick, an increase in the number of C4 organizations that were advocacy organizations. They were advocating on various things, which is a fine thing for a 501c4 to do. It's politics that isn't really considered to be appropriate 501c4 behavior past a certain threshold, because they can do politics. And what is politics also, Congressman, is, it may not be what you and I would think of politics as. It's politics under the Internal Revenue Code, which is really campaign intervention. It's endorsing or arguing against a particular candidate for public office. That's politics. So, I am aware that there was an uptick of organizations that came into us for exemption. So it was the determination letter process, not the examination process. I'm aware that some 200 501c4 applications fell into this category. We did group those organizations together to ensure consistency, to ensure quality. We continue to work those cases. My understanding, Congressman, is something over 50 of the 200 have received exemption already. More will. But many of these organizations fall into the category that I was talking about with Congresswoman Jenkins, where they are very small organizations and they're not quite sure what the rules are, and so we're working with them to ensure that they understand what the rules are. It's my hope that some of the noise that we heard earlier this year has abated as we continue to work through these cases.
Yes, we've had many constituents call, and there's a lot of blog activity. There's a lot of activity on the Internet talking about potential legal fees in the hundreds of thousands of dollars in fines in this group. So what is the potential if a group crosses over the line from being advocating a certain policy over into the endorsement, the campaign endorsement realm?
So if they're coming in for application to be recognized as a social welfare organization and they don't receive that recognition, then they would just not be a tax-exempt organization.
So what about organizations that have already received the recognition, but somewhere along the way have shifted their emphasis to where, is there an audit process? Is there?
There would be an audit process to determine what was their primary activity. Was their primary activity good 501c4 work, societal benefit, community benefit, social welfare, or something else? And the something else could include much more than just politics. It's just and so if we found that they were not primarily engaged in social welfare activities, we would revoke their exemption or work with them, as we do oftentimes, to move forward in an improved way. There also would be under the tax rules some possible tax based on the lesser of net investment income that they had or the political expenditure itself under the code.
Thank you, Mr. Chairman. Professor Colombo, it's easy to imagine an instance where a tax-exempt organization would participate in a soup kitchen kind of scenario, and then everybody liked the soup, and so started canning the soup and then selling it and made that. But can you describe in better detail how one analyzes a for-profit activity and at what point the activity jeopardizes their tax-exempt status?
Well, I think in my world, a commercial activity is one that competes in the private market with products and services available widely in the private market. So I'll use my example of the selling soup. I don't know whether selling soup is related or unrelated to operating a soup kitchen, but I am quite certain that it is a commercial activity. It competes in the private market with other soup makers. How about tuition charged by a private school? Well, that one I would say is not a commercial activity because we have not yet reached the point where educational services are widely available in the private market. There are a couple. I mean, there's the University of Phoenix, but we're not there yet. So my view about that one is that tuition charged is not. So I would look to the private market, and I would say that if what the charity is doing is selling a good or service that is widely available in the private market, that's a commercial activity. Where would I draw the line? I actually wouldn't draw the line. I would say to charities, you can engage in as much commercial activity as you want, provided that all of it is taxed and that you show us that that commercial activity is generating revenue that is expanding your charitable outputs. If it's not doing that, then why are you doing it? Do something else. Go sell your business and invest it in a diversified portfolio and use the money from your diversified portfolio to operate the soup kitchen rather than selling soup. You may not be good at selling soup.
So in my state, and in many states are now experiencing exploration, leasing income on the land that they own, so that someone comes to a local university, simple, that first box up there, they've never really even thought about getting out of that box, and all of a sudden they've discovered oil and gas on their campus or a piece of land that they've always considered to be their campus. That income is clearly not taxable?
I think under current law, it's pretty clearly a royalty if that's the way that it's structured. I come from Southern Illinois. We have oil and gas down in Southern Illinois too, but I forget how the oil and gas leasing is done in that situation. But I think it is pretty clear that it would be passive income, either as rental income from real estate or as a royalty arrangement.
And if they chose not to lease the royalty out and chose to drill, actually hire a rig and start drilling and producing their gas and oil, is that?
In my world, that's a commercial activity. Now you're shell oil.
And then, in your opinion, you would have an unrelated?
Yes.
Ms. Bornstein?
Well, if it were a school and you were teaching your students how to do that drilling and operate a business, you would be able to, under the current UBIT regime, talk about a substantial relationship to the conduct or accomplishment of your exempt purpose.
Mr. Tobin? Would you feel like that fell outside the actual participation in the drilling and becoming the producer, not just the royalty owner?
I agree with both examples. In the first example, I think if you actually engaged in the commercial activity and you became the driller, it would be much more problematic. And if you were able to make it part of your teaching process, then it would be less. I mean, we're talking about a hypothetical here, but it would be less problematic.
Thank you, Mr. Chairman.
Thank you, Mr. Marchant. Mr. Paulson.
Thank you, Mr. Chairman.